So at the end of yesterday, we were looking at the Court of Appeal's judgment in Singularis.
Yeah.
That then, of course, then went on to the Supreme Court, and Lady Hale gave the only judgment. That's in Authorities 2, tab 26. And one of the points taken before the Supreme Court was that if the fraud was attributed to the company, then the company's loss was caused by its own fault. And we can pick it up, I think, at paragraph 22, which is on page 1201. Where it says at the foot of that page, Daiwa argues that if the fraud is attributed to the company's loss is caused by its own fault and not by the fault of Daiwa. In Reeves and Commissioner of Police, Lord Hoffman referred to the sound intuition that there's a difference between protecting people against harm caused to them by third parties and protecting them against harm which they inflict upon themselves. People of full age and sound understanding must look after themselves and take responsibility for their actions. This was a case, argues Daiwa, in which the company inflicted the harm upon itself. Now, just pausing there, that is exactly this case. The duty for which the appellant contends would be tantamount to imposing on the bank a duty to protect the appellant from harm caused by herself. If we then turn the page to paragraph 23, Lady Hale goes on to say, against that, Lord Hoffman went on
That is, with respect, begging the question. I mean, obviously, if one were dealing with an unwise investment, you could legitimately say the appellant had brought it on herself. But here, the appellant has been deceived by a fraudster, and the issue is not is whether the bank, in those circumstances, is under a duty to take steps to protect her against the fraudster.
But
it depends how you formulate the issue with respect.
Well, one is still looking at the nature of the relationship between the bank and the customer. Well, that's the important point. One is trying to identify what is it that the bank owes to the customer. And obviously, in that situation, both the bank and the customer are innocent parties, as it were. And then paragraph 23, against that, Lord Hoffman went on to say that this philosophy expresses itself in the fact that a duty to protect a person of full understanding from causing harm to himself is very rare indeed. Once it's admitted that this is the rare case in which such a duty is owed, it seems to me self-contradictory to say that the breach could not have been a cause of the harm because the victim caused it to himself. And then Lady Hale says, this is just such a case. The purpose of the Quincecare duty is to protect a bank customer from the harm caused by people for whom the customer is one way or another responsible. So that, my lords, reinforces that the duty is only concerned with an internal fraud. In other words, a fraud by the authorised signatory on the customer, because the customer is, to use Lady Hale's language, one way or another responsible for the actions of the authorised signatory. The same point can be seen in paragraph 35, page 1205, where it says the context of this case is the breach by the company's investment bank and broker of its Quincecare duty of care towards the customer. The purpose of that duty is to protect the company against just the sort of misappropriation of its funds as took place here. By definition, this is done by a trusted agent of the company who is authorised to withdraw its money from the account. To attribute the fraud of that person to the company would, as the judge put it, denude the duty of any value in cases where it is most needed, paragraph 104. And if the appellant's argument were to be accepted in a case such as this, there would in reality be no Quincecare duty of care, or its breach would cease to have consequences. That would be a retrograde step. So again, my lords, that is consistent and only consistent with the Quincecare duty applying in relation to an authorised signatory situation. So we say, with respect, that the cases all speak with one voice, that the Quincecare duty is limited to a situation where there is suspicion that an internal fraud is occurring. And there is not a single instance where it has been held to apply to an external fraud. In other words, as in this appeal, a fraudulent payee has duped the customer into making payment. Now, my learned friend Mr. Sims sought to suggest that his argument was assisted by the decisions in Selangor and Korak Rubber. But these decisions were just early manifestations of what became the Quincecare duty. And you will recall that Mr. Justice Steyn referred to them in his judgment. Both cases concerned internal frauds. In other words, an authorised signatory acting in fraud of the customer. Okay. If we look briefly at Selangor, volume 2, tab 22, so I want to show you just one passage that I don't believe you were taken to yesterday.
Page.
Sorry, 1608. And it's the passage starting below the letter E. It was submitted for the defendants that whereas here, in the ordinary way, accompanied by a board resolution, authorises persons to sign cheques on its behalf and provides that cheques so signed shall be valid and binding on the company, and that the resolution shall be communicated to the bank and continue in force between the company and the bank until terminated as specified, then the bank is only concerned that the cheque should be signed by the authorised persons. If this were so, then it seems to follow that even if the bank actually knew that the authorised signatories were misapplying the company's funds, it could nevertheless rely on their signatures. This could be so outrageous as to lie outside the intention and true construction of the mandate. The mandate does not give the authorised person's signatures any more conclusive effect than in the case of an individual's account. A mandate gives the signature of that individual's duly authorised attorney, as for example in Midland Bank and Reckitt. The mandate is to enable the signatories to sign on behalf of the company and bind it vis-à-vis the bank. Clearly the signatories, because they were authorised to sign on behalf of the company, could not rely on the mandate to pay for their own purposes. In reality, they would be signing on their own behalf. Nor could the bank rely on the mandate as conclusive to make such payment for the signatory's purposes out of the company's account. Neither the signatories nor the bank would, in my view, be excused by the mandate from any obligation which existed independent of the mandate, such as obligations under their respective contractual relations with the company. As between the company and the bank, the mandate, in my view, operates within the normal contractual relationships of customer and banker and does not exclude them. These relationships include the normal obligation of using reasonable skill and care, and that duty on the part of the bank of using reasonable skill and care is a duty owed to the party to the contract, the customer, who in this case is the plaintiff, and not to the authorised signatories. And it extends over the whole range of banking business within that contract. So the duty of skill and care applies to interpreting, ascertaining and acting in accordance with the instructions of the customer. And that must mean his really intended instructions as contrasted with the instructions to act on signatures misused to defeat the customer's real intentions. Of course, omnia praesumenta right esse acta, and a bank should normally act in accordance with the mandate, but not if reasonable skill and care indicate a different course. So when Mr. Justice Ango Thomas there is talking about the really intended instructions, he's contrasting that with the instructions to act on the signatures which are misused to defeat the customer's action intentions.
If it matters, I have no idea what omnia praesumenta rite is.
Sorry, Lord, I had to Google it too, and it means that all things are presumed to have been done correctly. Correct rubber is to the same effect. That's at Authorities 1, tab 10.
It's a pre-storm judgment.
Authorities 1, tab 10. There's just two short passages here I wish to flag, which I don't believe you saw yesterday. Page 629. So just above the letter E, page 629, we see a sentence starting, none of the cases relied upon by the bank in support of its defence was directed towards the type of problem which I have to decide. That is to say, whether despite a primary obligation to pay a cheque on demand, a bank owes its customer a duty of care, which may, in an extreme case, oblige it to question the authority of an authorised signatory. And then we can go down just by the letter G, just above the letter G. The proper question, in my view, which should supposedly be put to paying banker and customer in a case such as the present, is whether the banker is to exercise reasonable skill and care in transacting the customer's banking business, including the making of such inquiries as may, in given circumstances, be appropriate and practical, if the banker has, or a reasonable banker would have, grounds for believing that the authorised signatories are misusing their authority for the purpose of defrauding their principal or otherwise defeating his true intentions. So Selingor and Karat Rubber aren't saying anything different to what became the Quincecare duty, and indeed that there is no authority that supports the conclusion that they were. Now, not only do we say is the Quincecare line of cases clear and consistent in relation to the proper scope and ambit of the duty, but in those cases in which it's been argued that the Quincecare duty does extend beyond a situation where the authorised signatory is acting in fraud of the customer, that argument has been rejected by the courts. Now, there are three decisions I would refer to in this regard. The first is the recent decision of the Scottish Court of Session in a case called Seekers and Clydesdale Bank. Now, for your note, we've dealt with this decision in our supplemental skeleton
Yeah,
argument.
this is the case that Mr. Sims says helps him and you say doesn't.
Yes. But
This is a decision of first instance in Scotland. Out of house.
I don't in fact propose to say any more on it than I've said in my supplemental skeleton.
Okay.
We've dealt with it, a core bundle.
You don't want us to look at it.
I don't, my lord, so all the passages I want to rely on are in my supplemental skeleton tab.
To be for myself, I've read it at some point. So.
And that, Lord Clark in that case expressly rejected the argument that the Quincecare duty could apply to an external fraud. So that's the first case. The second case is a recent decision of the Hong Kong Court of First Instance. That is at Authorities 2, tab 33. I'm not going to take you to it, I'm afraid, because I don't have time to do that. But like Seekers, that decision post-dated the judge's decision in this case. It's a lengthy judgment, which I'm afraid I don't have the time to take your lordships through. But if I may, I would ask you in due course to read paragraphs 143 to 182 and
143 to
182 and 216 to 225. And those
182 and 2.
sorry, 143 to 182.
Yeah, and 226.
And the 216 to 225. And those passages, you will see, chime in with much of what I've been saying over the last day or so, and expressly reject the notion that the Quincecare duty can apply to an external fraud. And again, that's an individual customer case where the customer was duped by a fraudulent payee. The third case I want to take you to briefly is a case called Virgini, which is a decision of Mr. Justice Hart in the Chancery Division. That's in Authorities 2, tab 30. Now, I will just briefly show you this, if I may. Now, this decision concerned an application by Mr. Virgini to set aside a statutory demand which had been served on him by the defendant bank. And then we can see the basis for that application at page 280 in the right-hand column. Okay. Just the second full paragraph down. In essence, Mr. Virgini's application is based on the proposition that the bank was in breach of a duty of care which it owed to him when it honoured the cheque. It being Mr. Virgini's case that the cheque was presented dishonestly in circumstances in which the bank should not have paid out in respect of it without making inquiry directly of Mr. Virgini. The circumstances in which the cheque is said to have been presented dishonestly are, according to Mr. Virgini, these. He says that at some date, he is not specific as to the time, he gave to a Mr. Sanjay, who appears to have been a business acquaintance or partner of Mr. Virgini, 2 blank cheques drawn on the bank and signed by Mr. Virgini. Mr. Virgini says that the understanding between him and Mr. Sanjay was that Mr. Sanjay would present the cheque for payment. Would not present the cheque for payment, I apologise, except for the purpose of withdrawing commissions owing from their joint commercial enterprises. Mr. Virgini says that it was in breach of that understanding that Mr. Sanjay filled in both dates and payees on both the cheques in late 1999 and thereby caused them to be presented for payment. We can then, I think, go to page 281 to the second full paragraph down in the left-hand column. However that may be, the essential ground upon which it is suggested that the bank was in breach of a duty of care owed to Mr. Virgini is that the bank ought to have realised that there was something wrong with the situation when the cheque was presented to it for payment, and should then have made inquiry, and that on the making of that inquiry it would have become clear that Mr. Virgini was not authorising the payment. And then we can go to page 282, to the left-hand column at the top. We see that reference there is made to Quincecare, and the judge then sets out a passage from that left-hand column, and then towards the bottom of that column, just beneath the hole punch, he says, I think, emphasise that passage is, of course, dealing with the standard of care required by a bank when dealing with the account of a company. In other words, a situation where the signatory of the cheque is necessarily not himself the account holder. Similarly, in Lipkin Gorman, where the question had to be considered both at first instance and in the Court of Appeal, the court had to deal with a case where the signatory of the cheque was not the only person who was liable on it. It seems to me, necessarily, the case that the possibility of fraud is always more likely to be present in a case where those circumstances obtain. In the present case, we're dealing with a situation where the apparent signatory of the cheque is himself the account holder. In those circumstances, if the bank has no reason not to believe the signature to be genuine, no question on the face of it can arise of some fraud being committed on the signatory. He is on the face of it requesting the bank to make payment at his expense. And the judge then goes on to cite some cases concerning cheques, and in particular the Barclays Bank, the well-known Barclays Bank and Sims case. Then over the page 283, left-hand column. For the reasons I've indicated, I do not think they were under any such duty. So that, my lords, is the case law. And the common law position that I've set out is also reflected in the statutory and regulatory regimes, as well as in the bank's terms and conditions. Now, we deal with the statutory regime in paragraph 31.1 of our appeal skeleton argument, which is core bundle 5, core bundle tab 5, page 56. And I'll just ask, if I may, the court to remind themselves of paragraph 31.1.
Page number again,
Oh,
please.
sorry, page 56, paragraph 31.1. So the short point is that the structure of the regulatory regime is to distinguish between authorised payments on the one hand and unauthorised payments on the other, with liability only falling on the bank for unauthorised payments, but not for authorised payments. And you'll see in that passage that we've included a reference to the payment systems regulator's report, which I'll come on to shortly. So that's the statutory regime. The regulatory regime is in the next paragraph of our skeleton, paragraph 31.2. And again, that only imposes liability on banks for unauthorised payments. Now, I would also add that the bank's terms and conditions reflect this distinction. And to be clear, I'm not relying on the terms, at this stage at least, as a means of defeating the claim. I'm just simply relying on them to show.
We can't, because we have to assume
Yes, exactly.
facts.
Yes.
I mean, that's one of the problems with this case. You have to assume what's in the particulars of claim is correct.
Yes, and the judge didn't.
So, as I understand it, that would make the terms and conditions immaterial. And whether they confirm what's, you say they confirm this distinction, fine, but that's not,
So
that shouldn't be a relevant matter for the striker.
Yes, I understand entirely, my lord. I mean, the
Totally
judge,
irrelevant to the present question.
the judge proceeded on the basis of the particulars, and indeed, I'm doing the same before this court.
Are we helped by the terms and conditions if we have to proceed on the basis that Philipp wasn't aware of them?
But, my lord, I'm not suggesting that. As I say, I'm not relying on them as a contractual stipulation.
What's their relevance?
Well, I was just simply identifying the terms do the same as the regulations, but I don't need the point because the regulations, as it were, do the work for me. So where does this all leave us? The bank says that the scope of the Quincecare duty is clear beyond any doubt. It does not extend to a situation where the fraud is external, and there is not a single case that supports the conclusion that it does. It is, we say with respect, unarguable to contend that it should extend to such a situation as a matter of principle, because such a submission would misunderstand the nature of the Quincecare duty and how it is a facet of the duty on the bank to exercise reasonable skill and care when executing a customer's instruction. In other words, the Quincecare duty itself is an aspect of the duty to ascertain, interpret, and act in accordance with the customer's instruction. Because it's directed towards the question whether the instruction coming from the authorised signatory is genuine. To find that the bank owes a Quincecare duty or something akin to it in relation to an external fraud, or even arguably owes such a duty, would, as I said yesterday, drive a coach and horses through the carefully calibrated duties under which the bank operates. Now, there are a number of aspects to this. First, it would put the bank in a position of inherent conflict with its client, the customer. The bank would have indisputably received a valid instruction in relation to which it had a primary duty to pay, and it would be liable if it did not do so. Yet it would, on my learned friend's argument, have to refrain from doing so. It's one thing requiring the bank to refrain from paying where it first needs to check that the instruction is genuine and valid. It's another thing entirely requiring it to refrain from paying where the instruction is indisputably valid. How is the bank supposed to balance the competing, indeed diametrically opposed obligations to which this scenario gives rise?
Speaking for myself, I find some of this rather overstated. Anybody with a bank account knows that if you're making a payment to a new account, or for a larger sum of money than you would usually be passing through your account, it's not always straightforward to do it. So to use your words, there is sometimes a conflict. One can be rather irritated. They have to ring you back. Sometimes that you have to speak to somebody else.
Sometimes you have to speak to the fraud department.
Well, the reason they're ringing you back is to make sure that it's properly authorised. In other words, it's the bank making sure it complies with the second duty I identified.
The bank is making sure that that's the payment you want to make.
Yes.
And that it's you at the end of the phone or whatever it might be. So there is a conflict. They don't act as an automatic cash dispenser.
I'm not at all suggesting that they do.
Well, you may be. Or that may be the effect of your submissions.
My Lord, that is not an intended effect. What the point I'm trying to make with respect is that when the bank, what the bank is trying to do in those situations is to make sure they are doing what the customer authorises them to do. And the reason they want to do that, obviously, is to make sure they have satisfying
Providing protection. But the question is where the limits of that protection are.
Yeah.
Well, Lord, they're not providing protection with respect. What they're doing is complying with the contract. That they are obliged to exercise reasonable skill and care in ascertaining, interpreting, and acting in accordance with the mandate. With the instructions. Now, as part of that, and in many senses this is where Quincecare comes in, the bank has got to make sure that actually those are your instructions. And that's why they phone you back, as they did here, to make sure that they were doing what the appellant wanted them to do. That they're not protecting you, as it were, against the world. They're simply protecting themselves, the bank, against the obligation they owe to the customer to do what the customer, to do as the customer wants them to do.
I'll tell you what strikes me is that you're trying to ride two horses, Mr. Coulson, at least in one sense, because some of your submissions sound as though you would say it this way. The real point is that this is all about protecting the bank, because worrying about whether the instruction is valid is about making sure that the bank doesn't soon do something it shouldn't do. And that's how you characterise the Quincecare duty. But that is too narrow, it seems to me, a view of the matter, because Quincecare, whether on one level it's about protecting the bank to make sure the bank only ever acts when it's got a valid instruction, which is part of Quincecare, ends up being to protect the customer. That's what the Quincecare duty does, it protects the customer. So it isn't right to say that this is just all about checking about the validity of authorisations from the point of view of the bank. It's not, it's about protecting the customer. You can't get away from the fact that at the end of the day, Quincecare is a duty of care which protects the customer. And that fundamental nature of the Quincecare duty is exactly the same as the issue we're being asked to decide in this case.
Well, with respect, that's not right. The bank is, to say it's protecting itself is perhaps putting it too colloquially. What I mean by that is the bank is under an indisputable duty to act with reasonable skill and care. And when it does the things that my Lord Justice Coulson referred to, like phoning the customer and so on, it's performing that duty. It's making sure that the thing is properly authorised. What the Quincecare duty is all about is the very same thing. Is this transaction properly authorised by the person who should authorise it, i.e. the customer, not the authorised signatory? So that's why they're directed towards exactly the same thing, my Lord. It's not, you're not protecting the customer in some general sense. You're protecting the customer from the bank acting on anything other than its proper instructions.
It's protecting the customer in a given set of circumstances, and the issue that we have to grapple with is whether it's arguable that the bank's under a duty to protect the customer in a different set of circumstances, which, from the customer's point of view, have the same deleterious effect.
But what one, my Lord, needs to understand how it is that duty might arise. Because one can understand very clearly, we say with respect, how the Quincecare duty arises where there's a question about the genuineness of the instruction. It's part and parcel of that second duty. If the bank is...
I mean, we pressed you on this yesterday, and I took a note, and by all means, tell me I'm wrong, or you don't want to pursue it on this basis. You said, when you were asked by the court, there is no duty owed to the customer, even if the bank employee suspects that the customer is a victim of fraud.
Well, Lord,
so this was in the context of this sort of, not necessarily of this case, but of an APP fraud where the bank employee asks the customer questions, customer is a bit, let's say, shifty, awkward. Bank employee thinks this customer may very well have been the subject of an APP fraud. I think there's something very suspicious here. And your case, as put to us yesterday, is the bank's under no duty to the customer at all.
Well, I think I need to be clear about what I'm saying. The bank is not under a contractual duty in that sense. But of course, the bank is exposed to all sorts of other problems in that situation, my Lord has posited. I mean, for example, the customer might have a claim against the bank in dishonest assistance if it feels the bank has acted...
Well, we're talking about less than dishonest assistance, that's the whole point. And that's all one view, where the judge went wrong, because the judge seems to have conflated negligence with dishonest assistance.
Well, Lord, with respect, he hasn't done that. But the point the judge made in the judgment below, which actually is a point that flows from Quincecare itself, is that the Quincecare duty itself arose out of the constructive trustee line of cases. That's the point the judge was making. He didn't conflate that at all. He recognised it was a contractual duty and said that it was instructive to see, as it were, the origins of the duty as to how it had developed. And one saw that actually in Mr. Justice Elliott's 5 classifications in Lip and Gorman at first instance, that they're all posited as constructive trustee principles, which the Court of Appeal then read across into a contractual situation. So the bank, in my Lord's situation, might well be exposed to claiming dishonest assistance. Equally, as I said yesterday, it's got its regulatory obligations, point with which we're interested, my lord, is the question of what legal contractual duty does the bank owe to the customer? So that was the first point I was making, the inherent conflict. The second point is that there's logic and principle, we say, in imposing obligations on the bank in respect of matters that bear upon its relationship with the customer. Namely, whether the instruction it has received is genuine and properly authorised by the customer. And indeed, it's clear in that situation how the bank can satisfy that obligation. It can go to the customer and check that the customer in fact wants to do what its authorised signatory is instructing the bank to do. So in that scenario, there is a readily identifiable and manageable line of inquiry that the bank can perform with relative ease in satisfaction of its obligation. And the bank would have been put on inquiry by something within its purview. Does the instruction that it has received from the authorised signatory give rise to any suspicions as to its validity? Now, where in contrast is the bank left if it's under the sort of duty for which my learned friend contends? Indeed, what is the relevant question that the bank is trying to answer in that situation? With the Quincecare duty, the point of inquiry is very clear. Is the instruction genuine and properly authorised? But once you move beyond that into the sort of territory my learned friend is urging upon you, what is the question the bank is seeking to answer? Is this transaction one that the customer really wants to do? Now, why would that line of inquiry be limited to scenarios where there might be fraud in play? Why not other transactions, the wisdom of which might be questionable? What if the bank thinks the customer is making a grave mistake, such as, for example, investing in a risky stock or making payment to a gambling account? What steps is the bank supposed to take in those scenarios? At the risk of stating the obvious, the law of tort imposes obligations on parties, but it must be predictable as to when an obligation arises and clear as to what it entails. It's one thing to require a bank to satisfy itself that a payment is in accordance with the mandate and properly authorised. It's another thing entirely to impose on it a duty to scrutinise the wisdom or motives of a properly authorised transaction. Indeed, the duty for which my learned friend contends goes well beyond the role that the bank would be required to perform if it had assumed an advisory duty. Yet my learned friend does not suggest, nor could he, that the bank was under any sort of advisory duty to the appellant. The third point is that all this needs to be seen in the context of modern day banking, in which banks are required to process a high volume of payments within short timescales. Customers expect and demand speedy transfers, yet on my learned friend's case, a bank would be in a constant state of anxiety as to whether it should in fact comply with the instructions.
wrong in remembering this particular transaction was one that you had a day to do? Client.
So I don't try to understand the.
Well, I can quite understand that if the transaction in question was one in which there was any sort of like a CHAPS system or a BACS or whatever expectation that it should happen within the next hour. I'm making up an hour just as an example. But I thought in this case, the bank transfer transaction, the way the terms and conditions or whatever the right expression is for this transfer means, the bank wasn't guaranteeing that it would make the transaction take place in less than about a day.
Well, not day. Wasn't.
It's 7 days actually.
It wasn't an electronic transaction either, because they went into the branch.
But
So it's much more like an old-fashioned transaction, where the bank has time to consider. I mean, I fully understand your point. If one were looking at, as my lord says, the BACS transactions or CHAPS or whatever, where millions of transactions go through each bank every day of the week, but this is just not that case, is it?
But my lord, if you were to find that the bank is under a duty or an arguable duty, there is direct read across to any sort of transaction. It's not limited to this transaction. That's the point I'm urging upon you. That the
Sorry, what isn't limited?
But if a bank is under a duty or an arguable duty to make the sort of inquiry that my learned friend has suggested has to be made in this case, that is of universal application.
Well, it's not, but it's not of universal application respect. It only arises where there's something about the transactions which either puts the bank on inquiry or ought to put the bank on inquiry. And in this case, what is said is, here was a lady whose account never had more than whatever it was, £10,000 in it. Suddenly it's got £700,000 sloshing around in it, which has come in from her husband's account, as it were, out of nowhere. And it's paid out to two entities in the United Arab Emirates. And what is said is the bank should have appreciated that it was something extremely odd going on. I mean, it's exactly the same as the point my lord made, which is where your bank thinks that you're paying out some huge amount of money to somebody. Quite often you'll get phone calls or you'll get text messages or whatever, you're asked to make all sorts of confirmations. And if the bank, in that example, even if it's online banking, were concerned about the transaction, then I think most of us would expect the bank to put some sort of stop on it.
Well, that's, with respect, my point. The way my lord put it there, concerned about it, that applies whatever the means of the transaction. So if the court were to find in this instance there's an arguable duty, there's no limit to that, and that applies across to any sort of.
We have to come back and remind ourselves we have not had a trial. The only issue for us is whether there is a reasonably arguable case that should be allowed to go to trial.
Yes.
And so anything that this court decides in relation to that is not saying there is a duty which therefore is to be translated across hundreds of thousands of transactions.
But
this is the trouble with these applications to strike out in evolving areas of tort, potentially evolving areas of tort. That suddenly there's all this in terrorem stuff about what the ramifications of what it is we decide, and we do sometimes have to take a step back and say the only point is whether on the facts of this case in these circumstances is it reasonably arguable that there was a duty.
Well, I don't want this to sound like a disagreeing point, but if the court were to find there was a duty here, or an arguable duty, there'd be no other APP fraud case which would be susceptible to summary determination. Because in every situation, the customer will be able to say, well, there needs to be some factual inquiry in line with what the Court of Appeal decided in Philipp before any determination can be made about the existence of a duty. And that would apply with respect, whatever the nature of the transaction, whether it's CHAPS, whether it's BACS, however it's done. because the customer would always be able to say, this case needs to go to trial, because the Court of Appeal has said there might be an arguable duty. So although I accept, of course, entirely that one is looking at this through the prism of this case, one does need to stand back and think about, you know, what is the consequences, or what are the consequences, more generally, of finding an arguable duty. And
Well, in a lot of cases, if it was you know £5,000 or £10,000 or £15,000, and it was done through backs or through online banking, there couldn't conceivably be any duty, because there'd be absolutely nothing that would put the bank on it. Well, there couldn't conceivably be a breach of duty because there's nothing that would put the bank on inquiry.
But, my Lord, with respect that one can't make that observation without in general terms. And what about a low-level account where money, £10,000 comes in and £10,000 is transferred out by backs or by chaps to an overseas account? Why wouldn't the same point arise there if this duty does arise?
Isn't the answer, Mr. Goodall, the one given by Mr. Justice Steyn in Quincecare, that the answer to the conundrum of how far do you go, not too far but far enough, is the standards of ordinary banking practice and ordinary prudent banker? And I know you're going to stand there and say, well, I don't know what that is, Judge.
No, so
but that's how the law works.
Well, I'm not going to say that. What I'm saying in response to that is, that observation is about a standard of care, not a duty. This case is about, as I said at the beginning, all about, is there a duty? It's not about the standard of care. The questions about the reasonable conduct of bankers or the reasonable practice of bankers goes to the question of, have the bank breached the duty? Not about the existence of the duty in the first place.
But your point was, when I asked you why you were talking about millions of transactions, because I said this one that takes 7 days, you very understandably, I don't think it's what you said before, but you very understandably then said, well, it's about the universal application. I get that. But isn't that about the standard of care?
No.
The question you're posing rhetorically is, what would the standard of care be in a back situation or in a chap situation?
I'm not, be clear, my Lord, I'm not posing a standard of care question. I'm posing a duty question.
Well, I understand you're saying you are, but the problems you're raising about it are problems of what the standard of care would be when there was a duty of care to backs payments.
Well, no, my Lord, the point I'm making at the moment is, if the court would decide there's an arguable duty here, there's no reason why that couldn't be read across to backs transactions, chaps transactions, so that any claimant could say, in any county court in any part of the country, my case must go to trial because the Court of Appeal have decided there's an arguable duty which can only be determined on the facts. That's the point I'm making. I'm not making any point about standard
How
of
the
care.
law works. So, for the sake of argument, the converse also true. If we decide there's no duty, then none of these cases can ever go to trial, and no one can ever find out. On the other hand, if we just say there is an arguable duty, then we have to have some trials, which is very inconvenient for everyone. We don't love it if we didn't have to have trials, but we do. And over a period, looking back over a period of years, the law would develop, and the boundaries of the duty would be defined, and the standards would be defined, and everything would work. That's how the law works, isn't it?
One of the problems with that is the point that the judge made below, is if one is going to impose some sort of duty on the bank, one has to actually identify and understand the framework by reference to which that duty is going to be performed. I mean, what is that duty? I mean, what is its proper ambit? Now, I mean, Quincecare identifies its ambit in the context of an internal fraud. If you've got an external fraud, how is one framing that duty? I mean, what is the scope of an ambit of that duty? How can the bank ever be satisfied that it's properly complied with what this duty might be? That's the real difficulty, my Lord. One needs to be clear about what it is you're saying is arguable. Because obviously, if the Court of Appeal decides this case is arguable, it goes back to the trial judge. Obviously, the trial judge needs to be told what he's doing. What duty is it being said actually is arguable? So the trial judge knows what inquiry and determination he's making at trial. And that's my point, my Lord. One needs to be clear about the duty that one is talking about. It's not good enough to say, well, there might be a duty here. One needs to say, well, where does this duty fit in within the indisputable structure of the duties that have been recognised by the law? Now that brings me on to my fourth
I
point.
mean, in Quincecare, what Mr. Justice Stein dealt with this in Quincecare, and we went through this yesterday, but he says this at page 376 at G. In my judgment, sensible compromise which strikes a fair balance between competing considerations is simply to say that a banker must refrain from executing an offer if and for so as long as the banker is put on inquiry in the sense that he has reasonable grounds, although not necessarily proof, for believing that the order is an attempt to misappropriate the funds of the company. And all that is being argued for here is that, rather than those last words, is that the order has been induced by fraud. So it's the answer to what triggers it is exactly the same answer when the bank is put on inquiry. And that's the answer to your suggestion. There's going to be millions of claims, because in most claims there won't be anything that could conceivably put the bank on inquiry.
Well, that with respect is wrong.
Mr. Sims is not arguing for, as I understand it, a wide-ranging duty that imposes on the bank an obligation to make inquiries in every single situation.
That is the...
Come what may. What he's saying is that on the facts of this case, which have yet to be resolved at trial, it may very well be that the bank was put in inquiry.
Well, that is... You might not be saying that, but that's the effect of his submission. I wanted to be very clear about that. The second thing is, Mr. Justice Stein was very clear to tie the on-inquiry test, as it were, or approach, to the order being an attempt to misappropriate.
Well, we've got your submissions about that, but what we're trying to do at the moment is to explore whether your interorum, as my lordships have described it, if your interorum plea has any force to it. And as my lord said to you a moment ago, what we're being asked to do here is to determine whether or not there's an arguable case to go to trial. And you may very well be triumphantly vindicated at trial, but the question is, should this case have been decided on a summary basis? And like my Lord Justice Coulson, I'm very concerned that cases of this kind, which involve potentially difficult issues as to the existence and scope of duties of care, are decided on this summary basis.
Well, Lord, I would say they do not involve difficult issues of scope of duty, because, for the reasons I've tried to explain, the duties are very clear, and there's simply no scope for this duty, and I'm yet to understand.
Well,
and it's, with respect to my lord, it's not an answer to say that the order was induced by deceit, because that doesn't make the order any less valid from a legal point of view, from the bank's perspective.
well, that's your argument, but I find that, I have to say, I mean, that comes back to, because that drives us back to what you had to accept yesterday, which is that even if the bank suspects that the customer has been the victim of fraud, it's under no duty to the customer. I must say, I find that a very surprising proposition. You may be right, our judge may or may not decide that in your favour.
My lords, my fourth point is this, that at the heart of what my learned friend is seeking is an issue of risk allocation. Who should bear the loss in relation to an APP fraud? And that is, with respect, a matter on which the courts are not best placed to provide an answer. There are a multitude of different and competing considerations and careful balances at play here, along with broader public policy issues, which are best considered and addressed by the industry itself, or through legislation or regulation. And indeed, the stakeholders have been working to provide an industry solution, which has resulted in the CRM code, which itself is the subject of ongoing development and consultation. And the judge rightly said below that if the duty was to be imposed, there would need to be a framework of clear and specific rules by reference to which the duty could sensibly operate. And with respect, the courts are not in a position to provide that framework. In fact, the money laundering regime provides a good comparison here. That whole regime, factoring in the various considerations and balances to which it gives rise, was introduced by way of detailed provisions of legislation and regulation. And the obligations, for example, placed upon a bank are clear and specific. And indeed, there is no obligation of investigation imposed on a bank, which is instead handed over to the National Crime Agency. Equally, it's clear that during the period that the bank has made a suspicious activity report and is awaiting a decision, it's permitted, as a matter of contract, to refuse to execute the payment instruction without any liability to its customer. That is in stark contrast to the position that would apply if an unfriend's duty were accepted, in which the bank may still be liable to the customer for breach of mandate in refusing or delaying the execution of the instruction. Now, I want now to pick up a number of other points that my learned friends have made. First, the CRM code. At the risk of stating the obvious, that the question that is before this court is whether the bank was under a duty, whether the bank was under the duty for which the appellant contends as at March 2018. It is not, the court is not assessing the position as at today's date. Although for the reasons I've already given, I would say the answer would be no different in any event. There is no dispute that the CRM code does not apply to the transactions in question. The CRM code did not come into effect until over a year later in May 2019. And even then, it doesn't apply to international transfers, so would not have applied to the appellant's transfers in any event. And perhaps most importantly, the CRM code is voluntary in nature. Only certain of the banks have signed up to it, and it does not give rise to any legal duties. The background to the CRM code only serves to reinforce that the bank was not under any relevant duty as at March 2018. The payment system regulator's response to which is super complaint in December 2016, it's worth looking at. That's in the supplemental bundle at page 248. This is the PSR's response in December 2016. And we can pick it up, I think, at page 274. Where we see a heading just above 4.5, complying with the customer's mandate. Where it says, to understand the current model of liability for APP scams, it's important to set these types of payments in the context of both the sending and receiving PSP's wider obligations. PSPs are expected to comply strictly with their customers' payment orders to the extent that they comply with the agreement that authorises the PSP to make payments upon instruction of the mandate. Indeed, a PSP's principal duty is to obey its customer's mandate. This position has long been recognised under the common law. The consequences of this are that a sending PSP cannot debit its customer's account where it acts outside the mandate, and on the other hand will be liable in damages for failing to comply with the badly executed payment order. Indeed, under legislation, PSPs now have time frames within which they must comply with a payment instruction made in accordance with the mandate. Under the Payment Services Regulations 2009, just pausing there, that those were the regulations in force in December 2016. That they've now since been replaced by the 2017 regulations, which implemented the Payment Services Directive. The general rule is that the sending PSP must ensure that it has credited the receiving account by the end of the next business day after it received the instruction. This means the PSP would have to reinstate the customer's account to the position it would have been in had the delay not occurred. A sending PSP's duty to comply with instruction that accords with its customer's mandate is subject only to limited exceptions. First, a sending PSP should not comply with a customer's payment instruction where it is on notice that an agent acting for the customer, such as a company director, is misusing its authority in order to misappropriate funds. And then we see footnote 25, a reference to Quincecare and Lipton Gorman. And then second, a sending PSP should not comply with a customer's payment instruction where the sending PSP knows or suspects that a customer is engaged in money laundering under the Proceeds of Crime Act. The PSP must instead disclose its suspicions to the National Crime Agency and seek that organisation's consent to take further action. And then over the page, 4.8, in the context of APP scams, since the customer has authorised the payment, the sending PSP's ability to prevent fraud is limited by its duty to comply with the mandate. While the sending PSP can try to dissuade a customer from making the payment in question or notify him or her of the risk of doing so, in the end it is obliged to comply with the authorised instruction and will be liable for failing to do so. A sending PSP, therefore, has limited options when faced with a customer that is determined to make a payment. So just pausing there, one of your friends said yesterday this document was focusing upon the regulatory position. It's not. It reflects both the regulatory position and the common law position. And then we have the heading liability for payments authorised versus unauthorised payments. 4.9, liability for payment services is governed by the PSR's 2009. But while the which super complaint draws the distinction between liability for push and pull payments, the PSRs do not. Instead, in terms of liability, the principal distinction in the regulations is between authorised and unauthorised payments. And then 4.12, under the PSR's 2009, PSPs will generally be liable for unauthorised payments. And then over the page, 276, 4.13, where a PSP that executes a payment can establish that the payment was authorised, however, it will not be liable for the customer's losses, even if it transpires that the money was paid to a scammer. The losses will instead lie with the customer. This reflects the limited ability of the sending PSP to prevent an authorised payment because of its duty to comply with the mandate. And then at the foot of that page, 416, the position under the PSR's 2009, reinforced by the courts, is therefore that neither the sending nor receiving PSP will be liable for losses stemming from APP scams. However, there remains one possible route by which a PSP may yet find itself incurring liability for such payments. The Financial Services and Markets Act provides for a dispute resolution scheme administered by the Financial Ombudsman Service. The Ombudsman Service can consider all disputes arising from the carrying out of regulated activities or payment services. The Ombudsman Service is not bound by the same rules of evidence as the court, and while it is required to have regard to the law, it is not bound to follow it. Instead, it is able to make its decisions based on what it considers to be fair and reasonable in all the circumstances. Now, I think yesterday there was some discussion about the FOS decisions in the bundles. But they are not, as it were, law. The Ombudsman is approaching the question from a very different perspective. He or she is approaching
To be
it.
fair to them, they're very clear about that. I mean, certainly the one that I read in detail said, in terms, I'm not suggesting this is the law, my obligation is to come to a result that's fair and reasonable.
That's right. So that's 416. Then we can go on, I think, to page 312. Which is a chapter headed "Our Approach to Addressing the Issues Identified."
Sorry, page?
Sorry, 312.
312.
Sorry, 312, yes. Our approach to addressing the issues identified. And then we can pick it up at the next page, 313. We have the heading important considerations in developing our proposed actions. And then various things are listed out there regarding what's labelled as the wider scam ecosystem. And then if we turn the page, 314, we see a heading balancing security with convenience and innovation. 8.7. Underlying the consideration of measures to tackle fraud in any payment system is the need to recognise that improved security measures could affect the extent to which payment system providers provide users with fast, frictionless payments. Such measures could frustrate the user, for example, by complicating the process of making payments or slowing down the time it takes for funds to reach the payee. APP scams relate to only a small percentage of total push payments, with the vast majority of payments being completed without issue or dispute. When considering any potential action, we are sensitive of the need to minimise the harm experienced by a relatively small group of users, though significant to the individuals affected, that is caused by APP scams, against the introduction of additional friction that will adversely impact users of the large majority of payments that are made without incident. And then the heading risk of creating adverse incentives. When considering potential changes to the liability model currently in place for APP scams, there is a need to understand the risk of any change creating adverse incentives for participants involved in a payment. For example, any change that results in consumers exercising less care in authorising push payments could result in an overall increase in the volume of APP scams. And then the risk of creating unintended consequences. We are mindful of the potential for unintended consequences to be created by any actions we take. This is particularly the case when considering potential changes in liability for APP scams. It is also the case for any action that may introduce significant additional cost or risk to industry participants. For example, interventions that result in significant changes in cost or risk to PSPs could be met by a range of responses from the impacted PSPs, such as an increased cost of the service provided to consumers, the withdrawal or scaling back of the supply of payment services to certain consumer segments, for example, those thought to be a particular risk of falling victim to APP scams, and the introduction of additional frictions for the use of payment services offered, or the scaling back in the capabilities of those services. So the regulator is making the point I made earlier. There's lots of different considerations at play here and balances that need to be struck. Then if we go on to page 317, we see the regulator expressly addressing which is proposed options for intervention. 820, both options proposed would impose greater liability on PSPs for APP scams than they currently face. And 821, we think that a wholesale shift in liability to PSPs that requires them to reimburse victims of APP scams, even with an exception where the victim has not acted fraudulently or with gross negligence, is inappropriate. And then 823, a change in liability would likely create adverse incentives and could actually result in an increase in APP scams. And over the page 318. 825, given there are a wide range of parties in addition to PSPs that have a role in preventing APP scams, an intervention that transfers liability entirely to PSPs does not appear to be appropriate where other solutions are available. 827. We think there is some merit in this proposal. We have asked the industry.
That's the second proposal.
Correct. We've asked the industry.
Introduce risk management standards.
We've asked the industry to develop a common approach or best practice standards that sending and receiving PSPs should follow when responding to instances of reported APP scams. We are of the view this will contribute to the rapid recovery of funds. So they ultimately decide that an industry-based solution is required because of the competing considerations and balances and factors that they have identified in the report. Against the backdrop of it being recognised that there was no statutory or common law duty on the banks in these circumstances. Now, the payment systems regulator then issued a consultation paper in November 2017.
And just so I've got the sequence right, there's the complaint, this is the response, then there's the consultation, which is at 334.
Yes.
And the CRM comes out of that.
Correct. The consultation 334, we see 337, the executive summary, para 1.3. They say we've worked with the payments industry to develop and progress a number of initiatives that should help prevent these scams and improve the response when they do happen. We also explored, or continue to explore solutions that mean victims are less likely to be out of pocket. We consider a contingent reimbursement model should be introduced to reimburse victims where banks have not met the required standards. And their proposal was, we can see this at page 374, paragraph 6.26. That the industry should lead the design and implementation of the model. The industry has the appropriate expertise and capabilities to take this forward in the most efficient way. And then 375, para 6.29, in our view, UK Finance is best placed to design and implement a contingent reimbursement model. UK Finance has access to the expertise to develop and operate a model. So this all reflected the complexity of the issue and the careful balances that need to have been struck. Now, the payment systems regulator reported on the outcome of the consultation in February 2018. That's at page 386. And decided to proceed with the CRM model. You can see at page 388, again in the executive summary, para 1.4, taking account of responses, we consider that an industry code developed collaboratively by industry and consumer group representatives that sets out the CRM rules is the most effective way to promote the interests of users of payment systems and services and reduce the consumer harm that APP scams can arise. If we then go to page 407, they say at para 3.99, we consider it important to introduce the industry code as soon as practically possible to protect consumers. However, we recognise there is a significant amount of work to be done to develop it. There are real risks of a poorly implemented code creating unintended consequences that may adversely affect both consumers and PSPs. And that's then what happened. The collaboration took place and the code was introduced at least in its first iteration in May 2019. Now, it should be recognised that this is not a static process. Since the code has been introduced, there have been further reviews and consultations in relation to the code, and various recommendations and changes have been proposed, or indeed made. And I don't have the time to go through those now, but the most recent word from the Payment Systems Regulator was in its consultation paper in November 2021, so just a few months ago. Perhaps we'll just briefly show you one passage in that. That's in the interveners bundle. Tab 3, page 100. And the proposal, or at least one of the proposals in this consultation paper, was that the CRM should be made mandatory rather than voluntary. And we can see that on page 103. Paragraph 1.3 in the third bullet point. Make reimbursement for scam victims mandatory. While there could be challenges with imposing this at present, we welcome the announcement from John Glenn MP, Economic Secretary of the Treasury, who has announced from the government that the government will legislate to address any barriers to regulatory action at the earliest opportunity. And then we can see at page 108 a bit more about that. At paragraph 2.2, where they say payment systems should be safe to use. We want PSPs to act to prevent APP scams from occurring and to ensure that victims are reimbursed. So far, we have advocated industry-led approaches to this, chiefly due to statutory restrictions on the actions we can take directly. And then there's the footnote 5, the Payment Services Regulation 2017, implementing the second directive, mean a reimbursement requirement can't be imposed on PSPs. Now, just to explain what is being referred to there, that the Payment Services Directive was a full harmonisation directive. So it wasn't open to member states to provide greater protection. And so the view the regulator took is that it couldn't, subject to a change in the law, impose a mandatory obligation on banks to reimburse victims of APP scams. The same point, we don't need to stand up, the same point appears in para 6.22 at page 143. So that's the CRM code. The second point I want to address is my learned friend's reliance on the BSI Code of Practice. Now, much the same can be said in relation to the Code of Practice, as I've said in relation to the CRM code. It is voluntary in nature. And if we look at that code, it's page 174 of the interveners bundle. Is the start of it, and then 177 is the bit I want to show you briefly. It makes it clear on its face that it's no more than guidance. We see on the right-hand column use of this document. As a code of practice, this PAS, and just pausing there, PAS stands for Publicly Available Specification. It takes the form of guidance and recommendations. It should not be quoted as if it were a specification. And particular care should be taken to ensure that claims of compliance are not misleading. And then...
Sorry, where?
Oh, sorry, 177, my lord. On the right, in the right-hand column.
Use of this document.
This is a British standard?
No, that's a point I'm going to just make very
It's
brief.
issued by the British Standards Institute.
Yes.
Sorry, issued by the British Standards Institute.
Even though it isn't one.
Yes.
It's not a British standard.
Correct.
So it's making it clear its guidance and recommendations.
Correct.
I'm fairly sure that the use of this document is a template, because I've seen other BSIs recently, and I think that's what you get.
Right. I suspect my lord is much more familiar with this area than I am, but as I understand it,
Well, not in the banking context, but I have seen these documents recently, and I think that's a template. But it's fair enough that they make the point that it is guidance and recommendations only.
As I understand it, the BSI can obviously issue what it terms British standards. That's not this document.
No.
If they're issuing a British standard, they are developed following a detailed and involved process led by a committee of a widely based group of experts with an interest in the matter, who then consult and reach consensus, which is then hoped will reinforce the authority of the standard. That's not what this document is. This is, as I say, a publicly available specification, or a PAS, which is developed in response to a commission by an external sponsor who funds the process. And here we can see on page 177 that sponsor was NatWest at the top, and they obviously funded it. And the process is designed to produce something in a short time frame and without the extended process and rigour that would be involved with the production of a British standard. So the end product is not a kite mark standard that one sometimes sees from the BSI. But in any event, the PAS at page 203 it expressly reflects the fact that the bank was under no legal obligation to customers in relation to authorised payments. And we see that on page 203 in the left-hand column, reimbursement of funds, and then just beneath note 2.
No legal obligation, but they should consider a voluntary
Yes.
reimbursement.
So that's the code of practice. The third point is one I briefly touched on yesterday, and that's my learned friend's suggestion that this appeal seeks no more than an incremental development of the law. Now there is, with respect to my learned friend, a certain schizophrenic quality to that submission. It's important to understand what this appeal is about and what it is not about. The notion of an incremental development of the law is one that has been deployed by the courts when considering whether a duty of care arises in a novel situation by analogy with established categories. But as I said yesterday, it's important to understand that my learned friend does not contend on this appeal that the bank owed a duty of care to the appellant in a caparo indictment sense. Instead, his argument is that the established Quincecare duty, which is not a caparo indictment type duty, should apply by analogy. Now, there is good reason why he is not running a caparo indictment type argument, and that is because the basic characteristic of the law of negligence is that liability is generally imposed for causing harm, rather than failing to prevent harm caused by other people. And we see that in Robinson and West Yorkshire Chief Constable, which is at Authorities 1, tab 19.
I've been slightly waiting for this. Is this the difference between making a bad situation? I can't remember quite how Lord Reed puts it, but it's making the difference between causing harm or preventing
Correct.
somebody else.
Correct.
Yeah.
And the relevant passage is 759.
Sorry, Robinson.
Oh, sorry, Robinson is at volume 1, tab 19. Page 759.
Your files are differently configured to ours.
Sorry. Where's my Lord's break?
Yeah. 19's in file 2. No, because
Oh, sorry, well, my break is at 22, so
well, you've got more weightlifting than we have.
sorry about that.
Don't worry. 19.
19, yes, so 7.
Yeah, Robinson, the Chief Constable.
759 at D. So he says, this is Lord Reed, just above the letter D, he says the central
Page?
point. 759. He says the central point is that the law of negligence, this is a D, generally imposes duties not to cause harm to other people or their property. It does not generally impose duties to provide them with benefits, including the prevention of harm caused by other agencies. Duties to provide benefits are in general voluntarily undertaken, rather than being imposed by the common law, and are typically within the domain of contract, promises, and trusts rather than tort. It follows from that basic characteristic of the law of negligence that liability is generally imposed for causing harm, rather than for failing to prevent harm caused by other people or by natural causes. Now, of course, as Lord Reed intimates there, in an economic loss case, the position may be different where the defendant has assumed responsibility to the claimant. And that was a point made by Lord Mance at page 763. Paragraph 83. This is 83. As Lord Reed demonstrates, it's unnecessary in every claim of negligence to resort to the three-stage analysis, identifying paradigma. There are well-established categories, including generally liability for causing physical injury by positive act, where the latter two criteria are at least assumed. The concomitant is that there is, absent an assumption of responsibility, no liability for negligently omitting to prevent damage occurring to a potential victim. But that is not this case. The appellant does not suggest that the bank assumed responsibility to her in relation to the transactions, nor could she, as nothing crossed the line between the parties from which such an assumption could be drawn. But in any event, in truth, my own friend's argument does not contend for a duty of reasonable skill and care as properly defined at all. Instead, he seeks to impose on the bank a duty of inquiry, which is quite different to a duty of care properly so called. So we say that the argument based on incremental development of the law is entirely inapposite, as it relates to a case that's not being run. Instead of a paradigma type duty, my learned friend's argument is that the Quincecare duty can apply by analogy, but there is no scope for an incremental development of that duty for the reasons I've already explained at length, namely that it is a bespoke, carefully prescribed duty that can only arise on a particular fact pattern.
That, as I understand it, the way it works, it arises as an implied term of the contract between the bank and the customer.
It's a facet of the duty of exercising reasonable skill and care in and about the.
Well, you could analyse in a number of ways. I mean, that's one of the ways in which it seems to be.
Yes. So one is not talking about incremental development in the way that that term is used traditionally. The fourth point I want to address. The fourth point I want to address is one that was made yesterday a few times. That the judgment below created what I think was described at one point as, quotes, a really weird distinction, close quotes, between companies and individuals. Now, with respect, that is wrong. In relation to APP fraud, that there is no distinction between the law's treatment of a company and an individual, that they are treated in precisely the same way. In neither case is protection afforded. because, as I've explained, the Quincecare duty is of no application to an external fraud, whether the customer is a company or an individual. The fifth point I want to address is my own friend's reliance on the money laundering regime. The first point to note about this is that the appellant does not plead that the bank fell foul of any money laundering obligations in relation to these transfers. But in any event, any breach of the money laundering obligations by a bank are not enforceable by a customer. And we don't need to turn it up, but we've dealt with that fully in our supplemental skeleton argument at Core Bundle 22, page 188, footnote 6.
Well, that's obvious because it's normally the customer who's alleged to be the money launderer. Not always.
Well, no, not always, my lord, no.
Not always, but
Even the obligations my learned friend Mr. McElroy took you to, the customer due diligence obligations, they're not enforceable by the customer either. The sixth point I wish to address, my own friend's, Mr. Sims' late reliance on the decision in Architects of Wine and Barclays. Now, that case, with respect to him, is entirely inapposite in the present situation. That case concerns the liability of a collecting bank, not a paying bank, to the true owner of a cheque. Now, just to set the groundwork here, and at the risk of teaching my grandmother how to suck eggs, a collecting bank does not owe a duty of care in tort to the true owner of the cheque not to convert the cheque. Instead, the duty of the collecting bank not to convert the cheque is absolute. In other words, if the bank pays the cheque to someone other than the true owner, there is strict liability on the bank for converting the cheque. And one can see that in paragraph 1
To interrupt you, it was my understanding, and I may be quite wrong, that we were only taken to this because of the relevance or the repeated references to evidence as to current banking practice.
Yes, but I just want to explain why that is not relevant in this case, because this case concerned the question of the application of Section 4 of the Cheques Act. But Parliament recognised that it was a very harsh outcome for banks to be strictly liable in every instance where they converted a cheque. So Parliament enacted the statutory defence in Section 4 of the Cheques Act, which is set out in paragraph 2 of the judgement. That in essence, where the banker acts in good faith and without negligence, certain things happen. Certain things are done. The banker then has no liability to the customer. So in other words, assuming that the bank acts in good faith, the question under Section 4 is whether or not the collecting bank was negligent in doing the acts referred to in the section. So in essence, Section 4 imposes a kind of statutory duty of care on the collecting bank, which is not owed in tort at common law. So that's an entirely different situation to the one with which the court is presently grappling, namely whether a paying bank, not a collecting bank, a paying bank owes a duty to its customer in relation to an APP fraud. Section 4, as I say, relates to a collecting bank and the true owner of the cheque, where the issue is whether the collecting bank has satisfied the statutory defence, including acting without negligence. And the present appeal is all to do with whether a duty exists. In contrast, the Architects of Wine case was all to do with the issue of breach and the standard of care that applies in relation to an accepted duty arising under statute. So we say that the decision provides no assistance to the court in determining whether the bank owed the appellant the duty alleged.
It's good. I've understood, I think, the real point of your submission. You say this is about standard of care, not duty. If I need to understand what a collecting bank is, I'm afraid you lost me.
So a paying bank, my lord, is the take a situation, my lord, where my lord writes a cheque to me.
Okay.
The paying bank is your bank.
Right.
The collecting bank is my bank. In other words, it collects money from your bank.
Right. So it gets the cheque,
It gets the cheque, and it then, through the system,
and then it gets the money.
retrieves the money from your. So it's collecting the money from your account,
Through the clearing
Right.
house.
and that's why.
It used to be done through the clearing house system.
Exactly.
Yes.
Which is described in
Okay.
great detail in Carrack Rubber.
Exactly.
The clearing thing is all, we've heard us
And it was all done through chaps.
And in fact, I mean, checks are now largely a thing of the past. In fact, I mean, through the pandemic of.
Chaps is clearing house automated payment system.
Correct.
Yeah.
No, that's very helpful, thank you.
And so when, I mean, to use the old language of checks, this is, I think, the point I made yesterday about the judges talking about the drawing of a cheque. In my example, my lord will be the drawer of the cheque. You've drawn the cheque,
Yeah.
and I'm the payee, the person to whose payment is being affected.
When was the last time you wrote a cheque?
I mean, there had been talk before the pandemic of actually abolishing cheques entirely.
Well, there have been talks about abolishing cash as well, haven't there?
So that's the sixth point. Sorry, the sixth point. Yes, the seventh point is my own friend's reliance on tidal energy. Now, as I understand his argument here, it seems to be said that when a customer contracts with a bank, it is doing so on the basis of standard banking practice, and that therefore, as he put it, standard banking practice goes to the issue of duty. Now, this, with respect, involves a misreading of tidal energy. That is at volume 2, tab 28. And this case involved a CHAPS transfer. And prior to the transfer, the customer completed a CHAPS transfer form. And on the form, they correctly named the intended beneficiary of the payment, but the account number and the sort code were wrong, as those details referred to a different entity. And we can pick up at paragraph 6, where the form is explained in the decision, in the judgment of Lord Justice Floyd. He says, and he's talking here about the form, that there followed 4 boxes, still within section 1 of the transfer form, giving details of the destination of the transfer. The boxes were entitled Receiving Beneficiary Sort Code, Receiving Beneficiary Bank and Branch, Receiving Beneficiary Customer Account Number, and Receiving Beneficiary Customer Name. Tidal filled in the first 3 of these boxes with the banking information with which it had been supplied, purportedly by design craft. These identified the receiving beneficiary bank as Barclays, but did not specify a branch. In the 4th box, Tidal inserted the name of the intended beneficiary of its funds, namely Design Craft Limited. And then we can go, I think, straight to paragraph 52, which is in the judgment of Lord Dyson, the Master of the Rolls, who gave the lead judgment for the majority. And he says, the question raised in this case is what is the proper construction of the CHAPS transfer form? In particular, did it authorise the Bank of Scotland to debit the claimant's account only when the payment was made to an account matching all 4 identifiers, sort code, bank name, account number, and customer name, or only when the payment was made for the first 3 identifiers? Lord Justice Floyd favours 1, the judge favoured 2. I agree with the judge, essentially for the reasons that he gave. So there was no issue in this case that the bank was under a duty to comply with the instruction. That's part and parcel of the second duty I referred to. The issue was what the instruction meant. How was it to be construed? And the answer was provided by Lord Dyson at paragraph 59, where he said that the instruction should be construed, you can see this in 59, in this way, a customer who uses CHAPS is taken to contract on the basis of the banking practice that governs CHAPS transactions. On the evidence which the judge accepted, there is a clear and settled practice that the receiving bank in a CHAPS transaction does not check the beneficiary's name for correspondence with other identifiers.
Sorry, which paragraph are you reading?
Sorry, 59, but the last 5 lines. There are good commercial reasons why.
Gotcha.
So the case has nothing at all to do with what duty the bank owed to the customer. That was not an issue. The issue was instead a narrow one as to how the customer's instruction should be construed. And so again, we say with respect, this is not a case that's going to assist in determining this appeal.
So I understand why what you're making, that the issue that the court actually had to decide, as you've shown us, was the construction of the form. I get that. Isn't the point Roman 1 that's referred to there in 59, which Lord Dyson is saying he agrees with his colleague Lord Justice Floyd, isn't that exactly what you just said the case wasn't about? It is there. The use of banking practices to decide whether the bank complied with its duty.
But Monol, he's talking there about when is banking practice relevant. As I say, the question in this case was, what was the construction of the construction of the instruction?
Yeah.
Obviously, we're dealing at a much earlier part of the analysis. Is there a duty? And banking practice can't tell you whether there's a duty. What banking practice is relevant to is the standard of care once you've identified that there is a duty. The 8th point is my own friend's reliance on the Court of Appeal's decision in Hilton and Westminster Bank. As I understand my own friend's argument, he said that that was a case that was an example of a case where the bank was on inquiry. But that, with respect to him, is a case that falls within what I have termed the second duty, i.e. the duty of skill and care in executing the instruction. All the Court of Appeal was saying in that case was that because there was an uncertainty and ambiguity as to what exactly the customer was instructing the bank to do, namely which cheque was in fact being countermanded, the bank should have been on inquiry as to the exact meaning of the customer's instruction. Therefore, the decision is a conventional application of the bank being required to exercise reasonable skill and care in interpreting and ascertaining the customer's instruction. And in any event, the Court of Appeal's decision was overturned by the House of Lords, and the House of Lords held that the instruction was ambiguous and that responsibility for that had to lie with the customer. That then brings me on to the 9th point, and that is that yesterday my learned friend Mr. McElroy said at one point, and I think this may chime in with what my Lord the Chancellor said this morning, that the will of the customer had been suborned by the fraudster, and therefore the position was analogous to the undue influence cases, as the customer intended the act, but not the consequences of the act. And we don't need to turn it up, but he makes a similar point in paragraph 21 of his written submissions. Now, my learned friend Mr. Sims makes a similar point in his skeleton, which I think we should turn up, at paragraph 72. So that's core bundle, tab 3, page 36. Where he says there in paragraph 72, the judge was wrong to reject any analogy with the rules in relation to undue influence on the basis that this case was concerned with common law wrongdoing. He ought to have recognised that whether or not it may be said to be a duty arising in equity, the courts already recognise that in certain unusual circumstances, bank may be required to take further steps to investigate and refrain from carrying out of the ordinary instructions, where they are put on notice that they may be affected by fraud or undue influence. Now, the fundamental flaw in this is that the undue influence cases do not relate to a situation where the bank is, to use my learned friend's language, carrying out ordinary instructions. As I've said previously, in relation to a transfer of monies, the bank is acting in an execution role. It's acting as the customer's agent and is not party to any transaction. The equitable principle of undue influence concerns an entirely different situation, namely one where the bank is actually party to the transaction, such as a mortgage or a guarantee. And the issue is the extent to which the bank is on notice that one of its counterparties is entering into the transaction as a result of the undue influence of another counterparty, with the transaction being voidable if undue influence is established. But when, in contrast, the bank effects a transfer for the customer, it is not in a counterparty situation with the customer. It's acting as their agent. And of course, there is no question of the transfer being voidable. Now, I will also just add that the extension of the constructive notice doctrine in Barclays Bank and O'Brien was itself recognised to be a development which was limited to a certain class of contracts. And we can see that in RBS and Ettridge. For me, that's in volume 1, tab 20, so I think that may be in your authorities too.
Which tab?
Tab 20. And we can pick it up at page 800, which is in Lord Nichols' speech, which was in the majority. We see above heading, above paragraph 34, the heading, the complainant and third party suretyship transactions. And then paragraph 38 on the next page, page 801. The jurisprudential route by which the House reached its conclusion in O'Brien's case has attracted criticism from some commentators. It has been said to involve artificiality and thereby create uncertainty in the law. I must first consider this criticism. In the ordinary course, a bank which takes a guarantee security from the wife or its customer will be altogether ignorant of any undue influence the customer may have exercised in order to secure the wife's concurrence. In O'Brien, Lord Brown-Wilkinson prayed in aid the doctrine of constructive notice. In circumstances he identified, a creditor is put on inquiry. When that is so, the creditor will have constructive notice of the wife's rights, unless the creditor takes reasonable steps to satisfy himself that the wife's agreement to stand surety has been properly obtained. Lord Brown-Wilkinson would be the first to recognise this is not a conventional use of the equitable concept of constructive notice. The traditional use of this concept concerns the circumstances in which a transferee of property who acquires a legal estate from a transferor with a defective title may nonetheless obtain a good title, that is, a better title, than the transferor had. That is not the present case. The bank acquires its charge from the wife, and there is nothing wrong with her title, to her share of the matrimonial home. The transferee wife is seeking to resile from the very very transaction she entered into with the bank, on the ground that her apparent consent was procured by the undue influence or other misconduct, such as misrepresentation of a third party, her husband. She is seeking to set aside her contract of guarantee, and with it the charge she gave to the bank. The traditional view of equity in this tripartite situation seems to be that a person in the position of the wife will only be relieved of her bargain if the other party to the transaction, the bank in the present instance, was privy to the conduct which led to the wife's entry into the transaction. And there's then, it says knowledge is required, there's reference to certain cases. The law imposes no obligation on one party to a transaction to check whether the other party's concurrence was obtained by undue influence. But O'Brien has introduced into the law the concept that in certain circumstances, a party to a contract may lose the benefit of his contract entered into in good faith if he ought to have known that the other's concurrence had been procured by the misconduct of a third party. And then we can go on to paragraph 43, page. The route selected in O'Brien ought not to have an unsettling effect on established principles of contract. O'Brien concerns suretyship transactions. These are tripartite transactions. They involve the debtor as well as the creditor and the guarantor. The guarantor enters into the transaction at the request of the debtor. The guarantor assumes obligations. On the face of the transaction, the guarantor usually receives no benefit in return, unless the guarantee is being given on a commercial basis, leaving aside cases where the relationship between the surety and the debtor is commercial. A guarantee transaction is one-sided so far as the guarantor is concerned. The creditor knows this. Thus, the decision in O'Brien is directed at the class of contracts which has special features of its own. So, my lord, this notion of the transfer being impugnable, as it were, because of some outside agency, is simply not one that's relevant to the relationship with the bank, because the bank is not party to that transaction. It's affecting it as agent. And in any event, as Lord Nichols says there, it's confined to a very narrow class of transactions. The 10th point I want to address is ground of appeal 6. The grounds of appeal are at Core Bundle 2, tab 14. And I don't propose to go through the grounds, because everything I've said so far addresses all the grounds, bar, I think, probably ground 6. Ground 6 is on page 16. I want you to remind yourself there of what's said.
Is this the delay point?
Correct. The 16th of March duty point. So the argument here is that even if the bank did not owe a duty when the payments were made on the 10th and the 13th of March, it nonetheless owed a duty on the 16th of March when it was notified by the police. Now, there's an issue as to what exactly the bank was told by the police on the 16th of March, which obviously I'm not going to get into. But even ignoring that point, this alternative case, we say, is untenable. The first point is that if the bank did not owe an earlier duty, no explanation is provided as to how it came under a duty subsequently.
It's a different instruction.
There's no instruction at all. The customers had no dealings with the bank on the 16th of March.
No. But the trigger, as I understand it, was the police tip-off.
Yeah. If the bank hasn't got a duty at the time of payment, how is this duty arising on the 16th at a point in time when...
So there was no duty to act on the police tip-off at all. So the fact they didn't do anything about it in May is nothing to the point. They could have done nothing about it for a year. Never do anything about it.
Well, in my learned friend's pleading...
That's right, isn't it? On your case, there's no duty, so it doesn't matter.
Let's assume for the sake of argument that the police say to them, look, this money's been paid out. The police tell them absolutely clearly that your customer has been the victim of a serious APP fraud. She's paid out £700,000 to two UAE entities which shouldn't have been paid. If the bank had acted on let's assume that if the bank had acted on the 16th of March, they could have got the money back. Are you saying that the bank didn't owe the customer any duty at all to do that?
Well, the bank's obligations are prescribed under the Payment Services Regulation. Those obligations include an obligation to effect payment within a prescribed time. They also include provision that once the instruction is given by the customer to the bank, the instruction is irrevocable.
So the answer to my Lord's question is yes. I am saying there's nothing, the bank were not liable in those circumstances.
No, if there's no duty at the time of payment, there can't be some duty that emerges later on when there's been no, there's nothing, as it were, to which it can attach to. The next point, my Lord, is, I think, the 11th point, which is that I stand by what I said yesterday, that the sentence in paragraph 22.51 of Paget regarding the bank not being liable for breach of mandate is simply wrong. There is no case cited in support of that proposition, nor has my learned friend identified one. I've shown you a number of cases, including Quincecare itself and Hilton in the House of Lords, in which it's made clear that the bank is in breach of mandate and liable for consequential losses if it acts in breach of mandate. My learned friend, I think, has sought to retrieve some previous versions of Paget, and I think it's fair to say that the source of the sentence is not clear. Certainly, it's been in the last couple of editions, but there's been no reference or citation in support of it.
Were those the things that came in?
Yeah,
this
one of the
morning?
things that came this morning.
Do you lordships want any spare copies? Or you all got?
Yeah, we've got.
But one we say contests the point as a matter of first principle. But when has it ever been recognised in English law that it is a valid defence to a breach of contract for the breaching party to say that they should not be held liable as they did not act negligently? There is no such concept under English law. But in any event, this is a bit of an arid debate because the common law position is now enshrined in the Payment Services Regulations. And if the payment is authorised, the bank is obliged to pay under the regulations. And if it does not do so, the regulations impose liability on the bank for losses caused to the customer. Two final points, if I may. Conscious I've got 3 minutes left. The first is, I may have misunderstood, but I think my Lord Justice Birss yesterday questioned whether the judge had recognised that the Quincecare duty was one which put the bank on inquiry. I think that's what my Lord said. We say with respect it's clear that he did. If you look at the judgment, paragraph 120. On page 95 of the core bundle. He says, I've already mentioned that Mr. Justice Staley Quincecare drew upon the first instance decision of Mr. Justice Elliott in Lipton Gorman. In my judgment, it's important to note in the relevant passage in Quincecare, quoted in paragraph 77 above, the court talked about a bank being put on inquiry. So the judge understood very clearly what Quincecare was about, and if one goes back to paragraph 77, which he refers there, which is on page 86, we see the long passage from Quincecare, including the put on inquiry passage that will be familiar to you. the same point actually emerges in paragraph 108, where he summarises Mr. Sims's argument as to what was sufficient to put the bank on inquiry. So the judge understood as well what the target was under Quincecare. So that's that point. Finally, the infamous Venn diagram, which I think my learned friend emailed through to my Lord's clerks this morning. This, with respect to my own friend, sets up a false dichotomy. As I said on a number of occasions, the bank does not dispute that the Quincecare duty is a facet of the duty of reasonable skill and care. So looking at my own friend's Venn diagram, it accepts that within that top circle, reasonable skill and care as PSP, there is the green circle, albeit it's limited to authority, i.e. Quincecare. It's not the bank's case that there is the two separate circles as suggested at the foot of the page. Where the dispute between us is what in fact the green circle in the top Venn diagram actually extends to.
ML?
Money laundering.
Right. Thank you.
So it's not, it doesn't actually capture the. So, my lords, for all those reasons, the bank respectfully submits that the appeal should be dismissed.
Thank you very much, Mr. Coulson. Yes, Mr. Sims.
Let me see if I can work out the logistics. A few moments.
I think, Mr. Sims, that my lord will let you take your mask.
You better take the mask off because it'll be more difficult for anybody to
That
hear
was
you.
that was my equivalent of not unmuting, wasn't it? My lords, in relation to where we got to, I think it probably is helpful if I try and take the headings my own friend took and in the same order and take things quite briefly. Of course, I have in mind the indications, observations made by Lordships throughout the course of the hearing, and I haven't moved proposed ground 9. So the question for your Lordships is, as identified, whether or not we have a reasonably arguable prospect for the reasons which we've already identified in our opening. And what I propose to do is to take the points in fairly short order, bearing in mind the submissions I've already made in opening and the fact we're now on to day 4 of argument on a summary judgment application, including the court below. So the first point I was going to address was under heading number 1, points of reply on the first duty heading, my own friend's notes. And the question first of all raised was one which came from the bench as regards the passage in Paget. And so far as we can tell from our trawl back through Paget, kind thanks to Lincoln's Inn for providing information overnight to assist on this, it would appear that the relevant passage, as far as I can tell, goes back to 2003. If you sort of cast your way back through the various.
That's one of Mr. Hapgood's editions, is it? 2003, yes.
Yeah.
12th edition.
Yeah. And my own friend's wrong to say that no authority is cited in support of the proposition, which I think was the way he put it in his submissions. But when I think your lordship identified that there was in fact an authority cited, it was then identified that we did have an authority, and it is in fact already in the bundle. And the authority cited is the Royal Products Limited case, and it's page 199. Within that report, there's a discussion about the doctrine of strict compliance and it not applying to the transfer in that case.
Do you want us to look at that?
I mean, your lordship's hands, there are a few points I have to get through, but
Yeah.
it's the short point is that in that case, the question is considered as whether the doctrine of strict compliance applies. And what the judge says, in effect, in response to it, is no. If what you're suggesting is that there's anything which should be treated as affecting the terms of the contract in relation to a contract for a transfer, so the point still does come back to what are the terms of the contract. The discussion really starts, the first column, with where it says secondly. I think if you've got it, secondly, he submitted as a general proposition that the doctrine of strict compliance was to be applied. He says, I reject that contention if he means that there was some duty on Midland or National which required them to do more than to comply with instructions, as those instructions are to be construed as a matter of law, and then goes through the various different points, and then there's the marked up passage. I conclude, therefore, that no authority precludes me from holding, etc. Now, how does that support what those two sentences in Paget, and how do you reconcile that? What we say is that what is said in Paget reflects actually what is customary practice in relation to banking practice in this area. That the banks do reserve to themselves the ability to say no, where a reasonably prudent banker would do so. And you see that in the bank's terms and conditions in this case, and various different guides. And if it's not in the terms and conditions, it's likely to be incorporated into the contract for the reasons identified by Lord Dyson, Master Rolls, in Tidal. And you may recall that there are the paragraphs which lead to the paragraph. My learned friend took you to paragraph 59. The paragraph starts actually at 57, where he considers the law. So what we say is that the passage in Paget happens to be an accurate reflection of the general position in relation to banking practice, save for any particular exceptions or circumstances to the contrary. And that doesn't create any problem, because of course, from the bank's perspective, if it receives an instruction for an ordinary payment and there's nothing out of the ordinary, of course, a reasonably prudent banker has to comply strictly in accordance with the instructions. It comes back to the same basic point. In my respectful submission, what's said in that passage must be right, because if you remind yourself, Lord Justice Rose confirmed in JP Morgan and Nigeria, and as I understand it, my own friend now accepts this point, that the Quincecare duty is one aspect of the bank's overall duty of reasonable skill and care, which of course is an implied term in the contract, both at common law and under section 13 of the Act. Logically, it must follow that the commentary in Paget in 22.51 is correct, at least so far as the Quincecare subset of the reasonable skill and care duty is owed. And why should it be confined only to that subset?
Well, that's the critical question.
Well,
the appeals.
Well, exactly. We would respectfully submit, and I think my learned friend has now eschewed his terms and conditions, but actually, if you look at the terms and conditions relied on the bank in this case, I'll just give you the reference for the relevant page. It's supplemental bundle page 62. You see a table in the top right-hand corner. No promise is made at all as to a time frame in relation to international payments, importantly. And there are also other points I can make about the terms here, where at page 59, there are various points where the bank reserves the right to itself to not make a payment. And those reflect, frankly, what a reasonably prudent banker would do in the particular circumstances of that case. Not make payments, for example, when they're on notice of fraud, being an obvious one. Now, I think the next point I was going to make was a point which was taken, was under this heading, but I think my learned friend may have been responding to questions from the bench. It may not strictly arise under the first heading, but there was a discussion about Green and Royal Bank of Scotland and what that is an authority what that is an authority for. And my note indicated that my learned friend was suggesting that it establishes there's no right of action on the part of a customer that where there's no right of action on the part of the customer under FISMA, there's no concurrent common law duty in equal terms. I would just invite you to note that what actually was established by the Court of Appeal in Green and Royal Bank of Scotland was quite limited. It was simply that the mere existence of the regulatory duty of itself does not bring about the creation of a coextensive common law duty. And you get that from Lord Justice Leggett's analysis of it in the later case of Guestmin, more frequently cited for other reasons, but is instructive on this point, and that's behind tab 5. It's at paragraph 122, and it's marked up in your authorities button. So that's what I had under my list for heading number 1. Heading number 2, which was to do with the duty to exercise reasonable skill and care. My learned friend took you to a case called Redmond, the first instance decision of Mr. Justice Saville, and what he sought to draw from this case was a sort of a close attention to the formulation of the use of the words interpreting, ascertaining, and acting in accordance with instructions. And I think my learned friend seeks to treat these like a tablet of stone inextricably bound in with simply the question of authority only. Whereas we would respectfully submit, if you look at the articulation of that same duty expressed in various different ways in the different cases running from Hilton, you can see that it encapsulates this situation where the agent is on notice that the principal doesn't truly intend the outcome of what is a prima facie valid instruction which they have to comply with. Put simply here, did the bank know or have reasonable notice to believe Mrs. Philipp really intended to pay Lambie Petroleum if they knew that Lambie Petroleum was a fraudulent entity? But of course, we would submit they should owe such a duty for the same reasons that was exclaimed as being obvious in the line of cases from our opening submissions, which I referred to yesterday. Now, there is a little bit of an oddity about some of the reasoning of Mr. Justice Saville in Redmond, because it appears that he views the selling law duty as something required to give the contract business efficacy. That's perhaps why it's implied. I don't know if you picked up on that when you read it, yeah. But I struggle with that because, of course, the implied term here is both a customary one of common law and under Section 13, and it arises independently of any business efficacy test. I didn't understand my own friend to place any particular reliance on us needing to cross the threshold of business efficacy, and of course that submission would be tantamount to submitting that the Quincecare duty is wrongly decided. In fact, a large part of my learned friend's submissions, if they're really to have any logical analysis, are really an attack on the Quincecare duty, as we would submit is properly understood. And we would submit that it's probably difficult to reconcile the observations of Mr. Justice Saville at first instance with those of Lady Justice Rose in the Court of Appeal in JP Morgan and Nigeria. You may recall the passage at paragraph 40 I drew your attention to yesterday. Now, the third point I wanted to make was my learned friend sought to suggest no value could be extracted from the decision of the Court of Appeal and House of Lords in Hilton and Westminster Bank in establishing the duty in this case. And we would respectfully submit that that is an influential decision for a number of reasons, not least because it's referred to in all the Quincecare line of cases as being influential, but also because it's an example of a case where the bank was potentially on notice of a mistake, and the court did not stop, as the first instance judge did, in looking at just the question of mandate. It was looking at the question of a wider question of negligence in the context of a mistake. And mistake or fraud, they both come back to the same basic point, which is whether or not the agent is on notice that the principal's true intention is different from their actual instruction. The fourth point was Malone and Friend took you to two passages of Lady Justice Rose, Mrs. Justice Rose, as she then was in Singularis, and he sought to extract statements made by her in those passages in support of the proposition. She was saying the Quincecare duty was limited to company agency cases. But both passages, and the passages that he referred to, paragraphs 184 and 281, were in the context of her rejection of the attribution argument and the illegality defences in the context of a corporate case. One imagines she would probably be horrified to think that it was being suggested that she was deciding that there was no limit to that there was no possibility of any other duties being owed in the context of fraud. Not least, we can glean that from our observations in Nigeria and JP Morgan, paragraph 40. Fifthly, so far as the question of incremental development of the law, my Lord Justice Birss asked for what's the law on this. I think Malone and Friend has assisted somewhat this morning in terms of drawing your attention to one of the authorities we cited in our skeleton argument. But the skeleton reference, if you want it, is paragraph 51 of our skeleton, where we do make clear that we are running our case on two bases. One, we're already within an existing established category of duty, and two, in any event, if there's a need for an incremental development of the law, this is such a case. And we referred to the most up-to-date guidance of it in Robinson, which discusses Caparo from paragraph 21 onwards. The key passage, I think, is paragraph 26, and we cite that in paragraphs 27 to 29 of our skeleton, I believe, is the reference I've got. I just checked that because it appears to be slightly different from the one I just gave you. Sorry, my notes gone awry there. I think it's 51 of our skeleton, but it's paragraphs 27 to 29 within the judgment. So it's 21, 27 and 29. My apologies. Next, Lipkin Gorman in the Court of Appeal. Malone and Friend rightly recognised the majority view in the Court of Appeal as that of Lord Justice Parker, as concurred with by Lord Justice Nichols. He placed heavy reliance on some of passages in Lord Justice May's judgment, in particular at 1356, in order to breathe new life back into the automatic cash dispenser point. But of course, that clearly is odds with the majority view, in particular that of Lord Justice Parker, and I've already taken you to the passages in that respect, which come firmly down against that. In addition, if you look at later cases, such as the Nigerian JP Morgan in the Court of Appeal, if you look, for example, at paragraph 13, it's Lord Justice Parker's judgment, which is influential. Can't see any indication, contrary to what Malone and Friend submitted, that it is Lord Justice May's view which has been taken up subsequently and applied in relation to that particular area he was focusing on. Seventh, we respectfully disagree with Malone and Friend that this is a pure question of law, but if the last couple of days has, has shown us anything, we would be wise to heed the observations of cases like Barrett and Enfield and Barrett and British Airways, as obviously referred to in AK Investment, in the Kurgis case, which is referred to in paragraph 81 of our skeleton, namely that these types of cases shouldn't be determined on a summary basis. My point 8 was Malone and Friend made an interesting observation about Quincecare being consigned to the dust and he revived again in singularis, and he appeared to hint that may have some significance. I detected in those submissions more than a hint that in some way this might be an aberrant line of authority. But he's not sort of challenging it at all in this court. He accepts that it is a valid line of authority. The trouble he has is if you look at the underlying reasoning in relation to it, it's firmly against him. And he only gets to the conclusion he wants by seeking to restrict its application solely to the facts that were before that court, as opposed to the reasons why the court concluded what it did on the facts of that case. And our respectful submission, actually, when one digs away at all of this, the point comes down firmly against him. But, of course, our fallback position is reflected in the fact that this court is not being, in any event, invited to determine a summary judgment in our favour, unless we move to our ground line, for which reasons indicated we haven't. Now, my learned friend took us to Virgini this morning. You may recall that was, I think, Susan Justice Hart. He skipped over a pretty key part of the judgment. I just want to take you back to it.
Yeah. Which tab is that? Tab 30.
Tab 30, is it? My note. My note indicated that my learned friend faithfully took you up to page 282, and then the second column he stopped when we got to the sort of the parts where it said the general duty of a banker, and then he went to the end, the phrase at the end, 283, applying that test. We would in particular invite you to look at below the quotation from Barclays Bank and Sims, the two passages.
The passage that starts on the face of it.
No, the one that says "it seems to me." Is
Well,
that
both actually. Both those passages make clear it's
something in the circumstances which were or should have been present to the bank's mind when the cheque was presented should have given it pause for thought. That's your point, isn't it?
Exactly, and also on the face of it.
And then in that next bit, he
Only
looks to see what the bank knew or could have done.
Exactly. So what he's saying is, normally, in a case where there's no agency, you're not likely to have the bank being put on notice of fraud. Actually, we would submit in this case supports our propositions and is actually against my learned friend for that reason. And he's not really sought to address that before the court. We would submit that our submission is entirely consistent with Mr. Justice Hart's analysis. So that's Virgini.
Which is the only English authority.
Only English authority, yeah. Architects of Wine, let's just remind ourselves, we're dealing in this case on our submission with a statutory implied term to exercise reasonable skill and care, in other words, negligence. What was an issue in Architects of Wine? Negligence. In the context of the burden being on the bank because of defending it from a conversion claim. Exactly the same concept. And what's instructive about Architects of Wine, why I invited you to read through from paragraphs 1 to 12, is because not only for the point that I identified, but also there's some interesting discussion in it about a bridge between why we get the Quincecare duty rising in circumstances where there's something out of the ordinary. And the way it's rationalised by Lord Justice Ricks really in that case is well, that's an indicator of negligence. Now, there may be an argument to be had as to whether or not that's the proper rationalisation or not. It's interesting to see it nevertheless in the banking context in relation to the application of the test of negligence. Now, I entirely accept, so far as the false cases are concerned, that those are not applying the strict law. But the reason why I took you to the false case, which I did, was just for the reference to industry practice and what was recognised. And the reason why those cases are significant is by March 2018, according to the Ombudsman, the bank already recognised that it needed to take steps to protect its customers from this type of fraud. It was an evidential point rather than the actual reasoning. But the reasoning, of course, we would submit, even if one applies the FOS test of what they think is fair and reasonable, is not a million miles apart from the Caparo extension in any event. But I think that might be a bit of a distraction for today's purposes. I don't think it's a significant point, but you'll have noted from our pleading that we plead both the matter on a contractual basis and also a tortious basis. And I've already addressed Tidal, I think. So just a few brief concluding submissions. When the going got tough, my learned friend in his submissions retreated to the position that he recognised the bank might be in breach of regulatory duties in certain of the scenarios posed, but not a duty which is actionable by the customer. Of course, certain of the regulatory provisions he referred to, CISC 6 in particular, SYSC 6 of the FCA, were dealing with the requirements of banks at a high level across their entire organisation. And you can see why the FCA may consider the issue of systemic compliance across the board to be one for them, not for the private customer. But it's not a justification from immunity from suit at common law, where, and I emphasise it, the facts justify it. I was reminded when listening to my learned friend's observations of some of the recently published words of Lord Justice Singh in his book on the unity of the law, where he emphasised the danger of silo thinking. If my learned friend is right, the banks are to live in a silo world, divorced from the rest of the common law, and we submit for no good reason. On the contrary, there are too many people like the Philipps who have suffered and will continue to suffer from APP fraud. We're 6 years on from the Which report flagging the problem, and the lacuna for international payments remain. I stress international payments being a typical and significant issue which arises in this context. Lord Justice Coulson reminded me gently yesterday of the seminal role played by Lord Atkins when I mispronounced his name and confused him with Lord Atkinson. I think it was Lord Atkins who used the phrase when observing the duty of care in the Hilton case, that he didn't think it was unduly burdensome on the bank to recognise the duty of care in the circumstances framed. That's effectively the same point as my somewhat less elegant phrase, what's the bank's beef? And one is still left scratching one's head, having heard my own friend, as to what really their beef is. The test is a modest one postulated by reference to reasonable banking standards. My Lords, if there are points of law where you consider that you can usefully give clarification on, of course, that would be appreciated by all the parties. That's, of course, a large part of your role. And I would concur with my learned friend that if there are points of law which you can usefully provide clarification on, that would, of course, be of assistance. For obvious reasons, we don't want to have to argue the same points of law for a first instance court again, unless that is unavoidable. It may be unavoidable for the reasons which you've identified. In concluding the ultimate issue, we've recognised that by not pursuing our ground 9, but it doesn't stop your lordships, obviously, from giving some helpful reasoning as regards the approach to take. And we would also recognise that there's little prospect of a matter such as this coming back before a senior court for some time to come, because it's obvious many personal customers don't have the financial resources or the nerve to take on their bank, as the Philipps have done in this case. We would respectfully submit it is a very odd concept that the role of the common law in providing a greater incentive to do the right thing by a customer is in effect being sought as an immunity in this area. And in our respectful submission, anything this court can do to assist in providing a level of stick to those who fall below what would be considered to be a reasonable standard is an obviously just and fair thing to do. In the circumstances, we would invite respectfully you to allow the appeal and to provide some helpful observations for the lower courts.
Thank you very much, Mr. Sims.
My Lord, I don't have a right of reply. Mr. Goodall made a number of references to the payment services regulations, but didn't take you to them. If you wish to hear from me as amicus on that point, I'm happy to address you very briefly on them.
Well, the trouble is we can then engage in forensic ping pong, where Mr. Goodall will stand up and say he's entitled to reply on your reply.
My Lords, for what it's worth, if I can just simply say this, as I think probably, if your Lordships will allow me, I certainly didn't accept any of my submissions what my learned friend Mr. Goodall was saying about the permanent services regulations in terms of their application to our case, in the sense of excluding a common law duty.
Well, the documents that we were shown this morning recite what the law is, what the law is in relation to Quincecare. They do not address this specific issue.
Exactly.
And the fact that the regulator may or may not think there's a duty in any given situation is interesting, but not determinative. It's for the court.
It's the point I made yesterday.
Yeah, it's the point that I said a moment ago that Mr. Goodall points to three authorities, one of which is Virgini, which, as you rightly point out, is qualified, and that's the only English case, and the other two are from other jurisdictions with no disrespect, they're not binding on us. So I'm not sure we'd be assisted, Mr. McElroy, by any further submissions. Thank you very much.
Well, can I just make one point on Virgini? I accept I don't have a right of reply, but I'm slightly concerned that the court might be operating under misapprehension. The point that's made in the passage that Lord Justice Coulson identified is a classic Quincecare point, i.e., was the bank on inquiry about the instruction? In other words, should they have seen the cheque and seen that because the payee had completed it, there was some problem with the instruction? So it's a classic Quincecare application as far as Quincecare applies at all. It's not a point where the court is saying that there's some duty going beyond Quincecare. In fact, he says there's no duty, but if my laws are reading it the way that my learned friend's inviting you, then that would be wrong. Because it's a question about the instruction still.
Something in the circumstances which were or should have been present to the bank's mind when the cheque was presented, which should have given you pause for thought.
Yes, the cheque presented.
Think about how far that goes, Mr. Goodall.
Cheque presented in circumstances where the payee, i.e. the fraudster, has wrongly completed the details.
Right. Okay, if you've all finished.
No further afters from me. No.
You won't be surprised to hear we'll reserve our judgment, we will endeavour to get it to you as soon as we possibly can. When you get it, please, only typographical errors and the like, not an invitation to re-argue the case. And if you can possibly agree a form of order between you when the time comes, we'd be grateful. Otherwise, anything that's left outstanding at the time of hand down will be dealt with by way of written submissions from the parties and a written order from the court. But thank you all very much indeed for your interesting and helpful submissions.